The event will begin shortly. We are waiting for all our guests to join the event. Thank you so much for your patience. Hello, everyone. My name is Shubham, and I welcome you all to KiwiTech's 808 workshop for startup and entrepreneurs to help them navigate the challenges of starting a business, making it sustainable, and taking it to the next level. Today, we have a mentor session on corporate and IP strategies to keep in mind to set your company up for success by Kate Cappaert, partner at Steptoe and Johnson's LLP, and Nick Palatucci of Counsel, Steptoe and Johnson LLP. I'm super excited to introduce KiwiTech, a one-of-a-kind innovation ecosystem that's home to 500 plus portfolio startups and 300 plus mentors, all committed to supporting innovators globally. It all began in 2009 when a team of seasoned entrepreneurs who had previously built and scaled a publishing services company for a 9-digit exit decided to start another company to empower startups with innovations. We have recently introduced a referral program at KiwiTech. This program rewards anyone who contributes to fruitful introduction to our company. Over the years, we have built this robust ecosystem of startups with the help of your trust and subsequent referrals. We realize it is time we give due credit to this trust through our referral program incentives. So if you know someone who's looking for tech development support to scale, join our referral program and follow the mentioned steps shown on your screen, or visit our website, www.kiwitech.com/referral program to learn more. Contribute to our growth journey and earn incentives for your trust in us. Without further ado, I would like to invite Kate Cappaert, partner at Steptoe and Johnson LLP, and Nick Palatucci of Counsel, Steptoe and Johnson LLP. The screen is all yours, Nick and Kate.
Thanks very much.
So we're going to do a brief presentation today to just talk through some sort of best practices, really basic stuff to keep in mind as you form your company and complete the early stages of your product development. I'm going to talk. My name is Nick Palatucci. I'm a corporate attorney. I'm based out on the West Coast. I've been working for about 10 years with startups, entrepreneurs, venture capitalists on corporate formation, fundraising, corporate transactions related to technology companies. And then Kate is going to talk a little bit about intellectual property protection, strategies for thinking about intellectual property as you start to develop it, and we're going to, I think, take some questions. So is my screen shared here? Let's see. I'm going to share now. It says loading. Okay, I think my screen should be up, but please let me know if it's not. Here's just a little overview of what we're going to be talking today. I think we'll just jump right in. So when you're thinking about starting your company, I guess the first consideration is what kind of company to start. I think this is pretty basic and you guys may know this, but I did want to go through some of the nuances around jurisdiction and formation issues. So typically, as you probably know, startups are formed as Delaware C corporations. There's a few reasons for this, which we'll kind of get into in some of the comparisons, but Delaware is a favored jurisdiction for corporate formation due to the fact that so many companies are formed there. A lot of attorneys and investors are familiar with the laws and the legal landscape there. There's a lot of certainty about how disputes would be resolved, et cetera. Occasionally companies come to us saying that they want to either have an existing entity in another state or that they want to form in another state. There's no specific reason that you can't do that. I do encourage people to maintain some flexibility. But the fact of the matter is when you are a early stage company and you are starting out, the last thing you want to be worried about is explaining to people that you have a non-standard setup and that it's going to take an extra layer of legal review and that there are going to be documents that the investors are maybe not familiar with, et cetera. So we try to keep things simple. And we generally recommend Delaware C Corporation for startup formation. A little bit about corporations versus LLCs. C corporations are a little bit more structured, so they're a little bit more constraining on the founders than an LLC. They have stricter fiduciary duties. The fiduciary duties cannot be waived. There's also a little bit more formality around issuing shares and issuing equity in the company. I think that is part of the reason investors are more comfortable with C corporations because they kind of don't have to look over your shoulder as much because they know that they're sort of protected from some of the things that may be able, the founders may be able to disadvantage them in an LLC format. And so they can kind of rest assured that they've got a Delaware C corporation. There is a different tax scheme for C corporations versus LLCs. Again, investors are typically more comfortable with C corporations because they do not have to issue an annual K-1, which is a tax document, which requires some work on the valuation of the company. Typically, in the early days, a startup doesn't want to put a lot of paperwork around its valuation because that valuation is highly variable, and so they don't want to necessarily make a definitive statement around the valuation of the company, and they certainly don't want to create tax liabilities for investors prior to a liquidity event, prior to there actually being money to pay those taxes. I'm going to skip ahead, but I just wanted to touch on a couple of other issues and happy to answer questions. One, I think this group may have already had a presentation on this, but for foreign companies, there's a very common structure called a flip-up, which we can use to form a Delaware C corporation as a parent of an existing offshore corporation. So that's a typical structure that is used if you already have a company in another country and you're looking to bring that company into the US, raise money from US investors, et cetera. And then the other place where sometimes we get into different kinds of corporate setups is in the cryptocurrency and blockchain world, where often we have an onshore entity such as a Delaware LLC, but often there are other sister entities or subsidiaries in offshore jurisdictions to avoid as much as possible US regulation, securities regulation, and other financial regulations. So that's where we start working with jurisdictions like the Cayman Islands, Bermuda, et cetera. A couple of words about employee equity, or sorry, founder equity. My first message on founder equity is always to issue the shares. Don't spend a lot of time procrastinating, arguing over specific percentages. The most important thing is to get the shares out the door so that you can have your company fully formed and you can get to work. There's a couple of reasons that you want to do that. One, again, is to just keep it simple and avoid controversy. The other is there are specific tax and valuation reasons that it's important to get the shares, or the majority of the shares of the company out as early as possible. So that's something that we make sure that people focus on, and that they don't sort of procrastinate and wait around until they have a fully developed product or a term sheet from an investor before they actually get around to issuing the shares to the founders. One topic that comes up often in these discussions is the concept of founder vesting. Founders often say, well, it's our company, why would we subject ourselves to vesting? Our recommendation generally is that if you have multiple co-founders, it's a good idea to have some vesting on those shares. Often we'll get into a situation where you'll have, let's say, 3 co-founders. One will not work out and they'll leave the company 6 months after formation, and they'll have a third of the company's cap table with no vesting. And so that will then be somebody that is going to have significant voting power in the company and significant influence over the company, but is no longer involved with the company. That's something that investors don't like to see, because it restricts the ability of the company to use their shares to incentivize people who are actually contributing. And certainly, if the relationship with that person isn't maintained, it can create problems navigating that shareholder as you try to go through normal shareholder transactions, such as approving changes to the charter, approving financings, approving mergers, things like that. You often want to put together an employee equity pool as part of your formation. Typically, those are somewhere between, let's say, 5 or 15% of your cap table. And what that is a sort of set aside to use for your employees going forward, so that you have room to say grant 1% or 2% to a founding member of the team. You might want to put some advisor, issue some advisor grants. So give 0.5% to somebody who has a good network, maybe an angel investor, or somebody who is in the ecosystem who can provide value, even though they're not an employee of your company. Happy to talk a little bit more about that if time permits in terms of strategy there. I mean, one thing I'll say is investors will often require that you have a certain percentage set aside when they finance your company. And so often it's good to put it in place yourself so that you can choose the percentage instead of being reactive when they come in and say, oh, you have to, not only do you have to give us shares, in exchange for our investment, but you have to set aside 15 or 20% of the shares for new hires. You're in a much better position leverage wise if you have that figured out before the investors come in. This point about shares in your company is just to say, I often see early stage startups fall into the trap of trying to grant everybody equity. And, I've had startup founders who try to grant their landlords equity as part of their lease agreement, using equity for small tasks by vendors or other people who are not going to have a long time relationship with the company. This is just a word of warning to always be careful. When you do equity grants, there is an administrative cost and a legal cost to doing the paperwork correctly, monitoring those grants going forward, keeping on top of them, dealing with requests from those shareholders. So the last thing you want is to be spending your time arguing with your former landlord over their share rights. Although equity can be a powerful tool to incentivize people and to help companies that are cash strapped get off the ground, just be careful about trying to pay for everything with equity, because often it can come back to bite you. And in the spirit of keep it simple, I think we typically advise founders to stick with one class of stock and not try to get into too many intricacies about super voting shares, different classes of stock, tax advantage stock, et cetera. Those things were very trendy, I think 5 or 10 years ago, and I think have fallen out of favor a little bit. I think a lot of that is because people got very fancy with the way that they wanted to form their companies and ended up wasting a lot of time, often creating tension with investors or others. And so, I don't mean to say it's a completely disfavored approach, but and there certainly are options if founders want to give themselves additional voting rights or additional liquidation preference or other advantages to the founder shares. But it's something that should be used sparingly and should not get in the way of the most important thing, which is actually growing the value of the company, developing the technology, et cetera. In terms of thinking about your initial board of directors, the CEO almost always has a place on the board. And at the initial stages of a company, if you don't have a lot of co-founders, often that's the only person on the board, which is fine for starters, but I think there's a couple other considerations to keep in mind. I think one is if you do have conflicts of interest or other issues where you're trying to figure out, so for example, your compensation as CEO or other things that affect you personally, it's sometimes nice to have one or more independent directors, or at least directors who are not the individual that whose compensation is being discussed, in order to evaluate those transactions and vote on them based on a disinterested basis. So if you can find either other co-founders or other trusted individuals to join your board at the pre-financing stage, it's often a good idea. Now, these are powerful positions, so you do really have to have somebody who's trusted and who's willing to be involved with the company going forward. Again, often for early stage entrepreneurs, those people are not necessarily available, but if they are, it can help in those sorts of situations. It can also help in terms of balancing the board as investors try to get seats. So if you bring in investors that want to, if you're a sole founder CEO who is the only person on the board, and the investor comes in and wants a board seat, all of a sudden you're going to have a 2-person board, and you're going to basically need to run every corporate decision through the investor. If you have 2 or 3 people on your board to start, you can tell the Series A director or the Series A investor that they can have a director's seat, but you still maintain majority control of the board, and that's something that'll put you in a more powerful position going forward. I'll keep going here. So then this is, I think, my last slide here, I think. Just talking a little bit about fundraising, and I'm sure this is some stuff that you folks have thought about and have learned about a lot, but just to kind of go through some of the basics. So at the early stages, your typical fundraising is going to be done through convertibles, either safes or convertible notes. I'm sure you're also familiar with the SAFE document. It's similar to a convertible note in structure, but it doesn't have a maturity date, it doesn't have an interest rate, et cetera. So the way that these financing instruments work is that they're denominated in a cash dollar amount. So somebody invests $10,000 in your company, they get a SAFE or a convertible note in the amount of $10,000. And that remains outstanding as denominated in dollars until it's repaid or otherwise retired, or the intended result is for it to convert in a equity financing. So it's sort of like a advance ticket to the equity financing. And that's, I think, the way that should be presented to investors. Unfortunately, I think investors are often not super sophisticated about these documents. They may be willing to use them, they may be willing to invest in them, but they don't always understand the terms. So I think it helps. I think it's part of the entrepreneur's job to present the investment vehicle in a way that makes the investor feel comfortable, makes the investor feel like they're, understand the value of what they're getting. And a couple places where that comes up. Safes, I think, enjoy a good reputation among technology investors, and that can be used to the entrepreneur's advantage, because they're just a known document, and investors know that other investors are comfortable with them, and so they sort of have faith in that it's a secure investment. I would say that's not the case necessarily for investors that are less experienced or less involved with technology companies. And so if you are targeting investors that are not sophisticated tech investors, but maybe investors that invest in other kinds of companies, investors that aren't centered around the sort of Bay Area technology scene, often those, the safe will require a little extra explanation to them, and they may not be comfortable with it. They may be more comfortable with a convertible note, which looks much more like a traditional debt instrument, which of course everyone is familiar with. A couple of notes on the valuation cap. So typically a safe will have either a discount or a valuation cap or both. What that means is that when it converts, it either converts at a discount into the next round of, the equity financing round, or if it's a valuation cap, that is just another kind of discount. But basically what it says is if the valuation of the equity financing is above, let's say $10 million, your safe is going to convert, or your convertible note is going to convert as if it was a $10 million valuation. That's very favorable to the investor, because it means that if you raise money at a $5 million valuation, they get the benefit of the lower valuation, and they'll convert just at the same price per share as all the other equity investors in that round. But if you raise at a $20 million valuation, they will convert as if they were at a $10 million valuation. In other words, they'll get their shares for 50% off. So it's sort of best of both worlds for the investors. Now that this goes back to my point about the investors not understanding these documents. Often the investors don't really understand that, and they think of the valuation cap as basically a stand-in for the valuation. And so if you set a high valuation cap, often the investors will think that you're saying basically, oh, well, we think we're a $25 million company right out the gate, and they may work to push that down, and you may have to negotiate on that basis. It's better if you can point out to them that this is a cap and not an actual valuation, and to the extent that you end up raising money at a lower valuation, they will get the benefit of that. So, good luck to you on getting that message through to investors. But, the unfortunate truth is that sometimes these documents are actually more favorable to the investors than they even understand, which makes it harder to convince them to invest. And then this last point about the 498 valuation is just to say that, part of the reason that we do safes and convertible notes instead of equity financing at the early stages is because we don't want to put a set valuation on the company. We want to say, well, the valuation is too uncertain at this point to determine, and we will figure that out at the equity financing. And so the idea is that when you issue a convertible note, that should not say anything definitive, although raising money, of course, it does say something to evaluator about the value of your company. Obviously, if you raise $20 million, your company is not worth less than that. But it shouldn't make a specific claim as to valuation. Whereas when you do an equity financing, like a true preferred stock financing, like a Series A, if you raise at $100 million valuation, an accountant, the IRS, others are going to look at that and take that as a very clear signal that your company is worth that much money. Again, the caveat there is that as these things have as the sort of investor understanding has progressed and people treat valuation caps as if they were stand-ins for valuation, accountants, valuators, et cetera, have started to look at the valuation cap as sort of a signal about valuation. So you'll want to be careful about the effect of even convertible notes and safes on your valuation, and you'll want to sort of be aware of that when you're talking to somebody who's valuing your company, and make sure that they're clear that the valuation cap is not a valuation. Even once you get to the equity round, I think there are some basic considerations that will come into play. We typically see what we call 1x non-participating preferred stock. That is very standard, and that's very, to be honest, favorable to entrepreneurs. So I think entrepreneurs should take advantage of that. Founders should take advantage of that, and consider that to be the absolute standard of the type of stock, and should be very resistant to investors trying to, at the early stages, negotiate for preferred stock or stock that converts at some kind of multiple. Happy to answer questions regarding the specifics of what those terms mean. Once you get to the equity round, you will have to think about a valuation for your company, and that's a tricky conversation that you should put some thought into, in terms of looking at companies at a similar stage, looking at comparisons, and sort of really understanding where you sit in the market, what your ability, what kind of valuation you can command, and how that's going to set you up for future fundraising rounds, et cetera. So that's something that it's important to put some thought into. I think investors often think of it just as a percentage. They'll say, well, I'll invest 5 million for 15% of your company, and then they just work backwards from there to figure out the valuation. And so, in that case, maybe it's not as driven by the fundamentals, but it will, obviously have an effect on what percentage they get, as well as either the stated value of your company going forward. So it's an important thing to think about. You'll have to figure out at this Series A round, it's much more common to have investors want a board seat, although not universally. So that's something you'll want to negotiate individually with the investor. And of course, you'll want to evaluate whether your investor will be a good partner and a good member of your board, because it can obviously be very disruptive if your investor is sort of only looking out for themselves, not patient, et cetera. That's probably somebody that it's going to be hard to have on your board at an early stage. And then this final point is the point I made before, which is that the investors will often ask to reset the equity pool in the equity financing. And so that's something that to look out for and be ready for. The difference between a $5 million investment and a $25 million pre-money financing with a 5% equity pool versus with a 20% equity pool is a big difference in terms of what that actually means for the true valuation of the company. And so you just don't want to get caught without having considered that when it comes time to negotiate a term sheet. I realized that was a lot, and I just, as I said, happy to answer questions, but I think that is my time, and I'll turn it over to Kate.
Thanks. And I will, Nick, to make this easier for you, I can share my screen. So let me know if you can see my screen. So I'm going to talk a little bit more now about the IP side of things. So I'm a partner in the IP group at Steptoe and Johnson, kind of focusing on all different types of intellectual property, primarily in litigation, but also just in terms of overall portfolio management and considerations that companies should think about as they're developing their IP portfolio and figuring out how to best use it. So I'm going to talk a little bit about what do you protect? So high-level overview in terms of the different types of IP considerations and types of IP. How do you protect it both from a pure filing with the US government, kind of USPTO type role, and then also from an internal to your company, how do you develop the protocols to protect your IP? And then what do you do once you actually have IP protections in place? So overall, I'm going to talk about 4 main types of intellectual property: copyrights, trademarks, trade secrets, and patents, all of which are a little bit different and all of which kind of have different levels of usefulness and kind of come up at different points in the starting of a company. So copyrights in general are original works of authorship. They're automatically protected as soon as you create it and put it in tangible form. 3 main things. 1, it has to be original, independently created by a human author without copying something else. Created, at least a minimal degree of creativity is required, and then fixed. It has to be in some sort of sufficiently permanent form. Kind of a hotbed issue right now is, how does AI play into that? In terms of, if you have aspects of a document or of a work that are generated by AI, is that copyrightable? The answer is that the AI generated parts are considered to, as of now, not be copyrightable. You're supposed to disclose that. The debate is still out there as to how that will actually be enforced or covered, but there is kind of some interplay and developments right now with respect to how AI generated work is going to come in for a copyright protection side of things. It's automatically protected, as I said, but you can federally register it. You don't have to when it's first created, but should you ever want to enforce your copyright, go after somebody for infringing on your copyright, it needs to be federally registered in order for you to bring a suit against infringers. So before you, again, you don't have to do it immediately once you have material that's copyrightable, but at some point, if you want to enforce it, you need to go to the Copyright Office and file for a copyright. It's a relatively quick process in the overall scheme of things, normally takes a matter of months to get through. Trademarks. So everyone has kind of seen the TM and the R symbol. They are different. So the TM is your common right. It attaches automatically. It allows for use within your state and for state protection. Trademarks in general are any word, phrase, symbol, design, combination of any of those things that is an identifier for your goods or services. It helps provide legal protection for your brand. It helps guard against counterfeiting and fraud. Again, you don't necessarily need to file. You have the common law right, and you can use the TM symbol for your trademark. But if you do file with the USPTO and go through the trademark process, the trademark application process, you get nationwide use, you get that R symbol. In general, trademarks are a good thing to kind of keep an eye out on, both for you to know if others are using your mark, and for you when you're kind of coming up with something that you think may be how you want to brand, how you want to develop a brand, checking to make sure that somebody else hasn't already done that they don't have a trademark, and that you're not going to go through the process of coming up with everything for your company only to receive a cease and desist or a takedown notice that you're infringing on somebody else's trademark. Again, you don't have to federally register, but you can. It's a USPTO process. You go through trademark prosecution, and it generally takes a year, maybe. It depends on whether there's office actions or whether there are issues. Other companies can come out and say that they have that trademark. Trade secrets. So trade secrets can be a lot of different things. It can be kind of buckets of information that don't fall into any of the other categories of copyright, trademark, patent. Your trade secret can cover things like formulas, recipes, source code, customer lists, manufacturing processes, technical know-how, a lot of different things. But the really important part of the trade secret is that it's secret. So it's valuable because you keep it a secret. It gives you some sort of competitive advantage, and it's protected. So in order to say that it's a trade secret, you can't just say this is a secret and then do nothing to make sure that you're protecting it. You have to make sure that you have protocols in place, have company kind of know-how and guides or guidance in place, employee agreements, things like that we'll talk about to make sure that you're protecting the information that you claim is a trade secret. It's a trade secret as long as it remains secret. So you don't file anything. The only thing that you have to do is make sure it doesn't become public. And we'll talk a little bit about that, but because trade secrets, there are two ways that they can kind of become public, or three ways they can kind of become public. One is inadvertent disclosure. You accidentally release the information somewhere, discuss it with somebody, and then it becomes public. Another is somebody takes it from you and they use it that way, or you make a decision to make it public. And then the third is reverse engineering. So say, for example, you have a formulation for some recipe, an ingredient list. If somebody is able to reverse engineer that or figure out what it is without you telling them and without getting that information from you, that's not an issue. They don't infringe, or they haven't misappropriated your trade secret, and your trade secret is now can be viewed as being in the public, and they haven't done anything wrong. So trade secrets are kind of a tricky area, and an area that a lot of companies have know-how and knowledge, and especially as you're kind of developing things, but just making sure that you have those protocols in place to protect them are really important at the beginning stage. Patents. Everybody's heard about patents. People talk about them. I know that a lot of times early stage companies are thinking, do I really have the money to spend on a patent? Do I want to spend this money on a patent? Overall, a patent is an exclusive right for an invention to exclude others from making, using, selling, offering for sale, or importing the claimed invention. Term of 20 years, and it's territorial. So that's in the United States. If you want patent protection in other countries, you need to file for patent protection there. It's a territorial type of thing, and you can decide where it makes sense, and there's a lot of strategic considerations for that. And we'll talk a little bit about how do you decide what to patent and when you want to patent. In general, though, so protecting IP, as I said, I'm going to talk a little bit about two different areas and forms for protecting your IP. One is on the company side of things. So how do you make sure that the individuals who are working at your company know what to do when they have an invention or have something that they think is a trade secret? Who does it belong to? What are the protocols and processes to make sure that it gets to the right people and that you have kind of everything in place? And one of the main things for companies to think about are having it clear in employment agreements. So having explicit rules regarding how proprietary information is going to be handled. Having explicit rules about returning or destroying company property, company information, to make sure that somebody who did work for you and maybe they had access to that trade secret material isn't able to just take it with them when they leave. Guidelines about what is confidential, steps that employees need to make to keep it confidential, passwords, need to know basis, things like that for your really sensitive information. And that goes a lot to the trade secret side of things. For the patent side of things, it's also about, on the employee side, ownership. So if you come up with if somebody comes up with an invention while they're working at your company, who does it belong to? You want to make sure that you have it in place that if there's an invention that somebody comes up with, it's assigned to the company, it's a company invention. So you don't have issues where somebody leaves, they take it on their own, and then they file a suit that your technology is infringing their patent. So just making sure that that is set forth clearly in employment agreements about in terms of IP ownership, that it stays with the company. And that's kind of from a company side of things. You also have like non-disclosure agreements, which will affect a lot of your discussions with joint research, investors, partners. If you have something that you think is really great, but it is proprietary, you want to make sure that anybody you're talking to has signed a non-disclosure agreement, has made sure that has acknowledged that they're not going to disclose any of your confidential information. And a lot of times, those sorts of NDAs have sunset clauses saying you won't disclose the confidential information for a certain number of years. You want to be careful in terms of structuring that to make sure that it's really buttoned up, tight, narrowly tailored language so that those individuals can't say, oh, well, the 2 years passed, so now I can go out and use the technology that I learned from you during that meeting 2 years and 2 days ago. Additionally, employee training on these procedures, on the protocols. If you have trade secrets, for example, making sure that people know, keeping them kind of in a need to know basis is often best. I realize in early stage companies, there may only be a couple of people who have it. So it's not necessarily insulating from a 700 person company, but just making sure that you have those protocols in place so that information isn't inadvertently getting disclosed is important. And getting it set up from the beginning so that as companies grow, you already have the protocols in place to protect your IP as it's being developed. Corporate policies are also really important here in terms of making sure that, say for patent protection, for example, if somebody identifies something that they think is patentable, who do they bring that to? How is it evaluated? When is it evaluated? To make sure that you don't miss a window for filing or it doesn't get lost in everything else that's going on. Having kind of set policies, set groups, set review meetings, for example, to allow kind of whoever you decide is going to be the arbiter of whether or not something is patentable, or if you want to move forward, maybe talk to outside counsel about whether you should seek patent protection, how you should handle the materials. Having that kind of structure outlined and in place from the beginning so that, as the company grows, as you are hiring additional employees and coming up with new ideas, you're making sure that you're really able to protect them moving forward and have all of those kind of guiding lines in place. And again, this is one of those instances in terms of protecting IP. It's not really a one-size-fits-all solution. It really depends on what type of IP are you working with? What is your company dealing with? Is it something where you're going to want to be filing for patents early? Is it something where you may be taking the trade secret route? Making sure, is your agreement really clear on what it's disclosing? And this is a time where involving legal counsel to make sure that all of your employee agreements, NDAs, company policies are set up to make sure that you are adequately protecting everything that you develop is a good thing to do. With respect to filing for kind of your trademark, your copyright, or your patent, for copyrights and trademarks, as I said, you don't need to file for them ahead of time. For copyrights, if you think that you're going to, it's not an overly burdensome process, but it is also not urgent. And you can, if you see that somebody is infringing your copyright, you can file for copyright protection then, and then kind of bring a suit down the road, or threaten, so you can send a cease and desist or take down notice. You just can't file in federal court until it's fully registered at the Copyright Office. Trademarks, again, if you want kind of that US-wide usage, you should go through the process of filing for a formal trademark. It's also good as well because it vets your trademarks up. So you have a better understanding of whether you are stepping into somebody else, a territory where somebody else is going to reach out to you and say that you're actually infringing on their trademark. It gives you kind of just that better knowledge and awareness before you go through a process of really devoting a lot of time and money putting into your brand. It's always unfortunate if you do that and then find out that somebody else actually has that as their brand and they tend to tell you you have to stop. In terms of a patent, patents are probably the most costly out of all of the different types of IP. They can, if they're used wisely, have a pretty wide-reaching effect and can be utilized in a lot of different ways. but it really comes down to a lot of a cost benefit analysis and seeing if what your technology is and what your industry, how it's doing and how it's growing. So it's not just kind of about protecting your invention now. If you're in an industry that's constantly changing and your technology may be obsolete in 2 years, maybe you don't do a patent. Maybe you think about your technology and your IP as more of trade secrets. If you think that this is kind of a building block, fundamental technology, it's going to continuously be used, it's going to be pervasive in your field, then that's the type of thing that you're going to want to file a patent on, make sure that you get it out there, that it's yours. It doesn't mean you have to go out and sue everybody. It doesn't mean you have to send cease and desist letters once you get it, but you kind of put your mark down that technology belongs to you. And should you ever want to go after somebody down the road or monetize it in other ways, you can. Knowing kind of, is it a niche environment for your cost benefit analysis? What is the scope in which the technology is going to be used? And then really figuring out whether it actually is patentable. And that's something where you can look yourself, you can look online to see if somebody else has come up with this technology before, or you can hire outside counsel to do a patentability search. They can look for potential prior art. They can help you through the process of filing the patent and going from there. Similarly, addressing workarounds. If you have a patent, for example, and I've seen them where your patent talks about using a certain color coding system for data. While that may be what you do and is inventive and you get a patent on it, if a company can just work around it by using a different color scheme or a different system of identifying the different data that isn't the specific color scheme that you've patented, maybe that's not where you put all of your money in terms of the patent. But if you have an idea, something that's really important to consider for patents is when you're going to go public. If you're going to be selling a product publicly, if you're going to be disseminating the information publicly, you have a year from when your invention becomes known to when you have to have filed that patent. And a good way, if you're still assessing whether a patent's the right thing to do, is you can file a provisional patent. It's not going to be examined. It gives you a 1-year buffer. It's more inexpensive than filing your non-provisional, your traditional patent that will go through the whole examination process. And it's not as formal. The requirements for actually filing a provisional application are lower. So it's a good way to kind of get your idea out there, put it down so that you have that 1 year to figure out how you want to handle it going forward. What do you do once you have the IP? So again, with copyrights and trademarks, I mean, you can just use them. You can attach the symbol. You can monitor to see if anybody else is using them, and you can always send notices if you think that somebody is infringing on your rights. Similarly with patents, so monitoring your competition, seeing what they're doing. You can, if somebody's infringing, you can threaten them with a cease and desist. They have to stop. You can resort to litigation and you can file a patent litigation, a lawsuit against them. You can also just try to monetize it. A lot of times, if you have a really inventive, pervasive technology that you have a patent on, you can reach out to other companies that are going to be using it and license it to them. And that's another way to kind of have that revenue stream coming from your IP. What is also important and something to consider on the flip side of these things is that monitoring your competition is great from a assertion standpoint, but it's also something that companies should be considering just to protect themselves from a defensive standpoint. Knowing what your competition is doing, knowing how they're doing it, just doing checks occasionally to see whether there are any other patents out there from your competitors that you may potentially step in if you create your product in a certain way, is just something that's really useful and beneficial. And again, kind of goes back to what I was talking earlier about having those ideas, policy in check in the beginning so that you have systems for monitoring. You know who's going to be doing that, when they're going to be doing that, and you know how it's going to be done. And again, this is something you can do internally. You can use outside counsel for it. It really just depends on a lot, again, on your company, the technology, and I'm happy to answer additional questions on that too. That was my last slide, so I can open it up to questions now.
Thank you so much, Kate, Nick. It was a wonderful presentation. So I would like to give a couple of minutes to the audience. And our mentors are ready for your questions. You can just type them down in the Q&A or chat. So we'll give it like around 30 seconds to a minute. Let's see if any questions come up. Okay, so we have one question. So how should I think about AI when assessing the scope of my IP? I guess this one's for you, Kate.
Sure. So I think AI is constantly changing. I think that when you're considering AI and how it's being used within your company and how it affects your IP overall, it doesn't necessarily make sense to put extreme checks in place to prevent the use of AI, things like that. But a consideration is both twofold. So on the protection side of things, like for copyright, things like that, you're not supposed to include AI as copyrightable work. But from a disclosure side of things, if you're using or asking ChatGPT questions or using it to generate source code, you may potentially be losing some of your IP or disseminating it into the public in ways that it's going to continue to be utilized and may show up in other people's future use of AI. So kind of just a consideration in terms of both what data do you want out there and what do you want coming back.
Wonderful. Thank you so much, Kate. So we have a couple of questions. What are some emerging trends or developments in the field of IP strategy that companies should be aware of?
I think it depends. I think that IP is always changing, and I think that you're seeing a lot more now of trade secret kind of becoming more prevalent. You still see a lot of patent protection as well, but keeping in, like, I think that IP in general is something that you'll get questions about. Oh, you have this invention. Do you have it patented? How have you secured your technology? I know that sometimes investors or funds will ask, and kind of figuring out how to put that and what technology you do want to file for protection on is really important. I think in terms of overall branding and marketing efforts, it's important to not disclose too much about what you're doing should you want to keep it protected. So kind of knowing that fine line between, is something a protectable trade secret? Is it something that you do want to file a patent on, so you don't want to disclose it to the public? For example, I've seen situations where companies have patents on manufacturing technology, for example, but 2 years before they filed, they had that manufacturing line up and running and they were giving tours to the general public where they could see it. So you run into issues in terms of what you're disclosing and how you're marketing yourself and branding yourself versus what you have protected. And I think that that's a fine line and is really a company strategy in terms of how much you disclose and what pieces of it without giving away kind of your whole technology.
Certainly. I am completely aligned with you on that. We have another question. I guess this one's for you, Nick. What form of employee equity is appropriate for early stage companies like restricted stocks, options, or RSUs?
Yeah, so I think a lot of companies right out the gate think of stock options as that's sort of how we generally talk about employee equity. But actually, at the early stages, what we typically recommend prior to your first equity financing, so prior to your Series A, as we typically find that it's easiest to just issue stock. And so, at this point, you're still at a low valuation. You can issue shares to the founders that they don't have to, or sorry, the early employees. They don't have to we don't have to set an exercise price. There are expiration dates on options. So as options, I believe, are only allowed to last 10 years. So you can eliminate that. I think the issue with the exercise price is we don't typically recommend that people issue options without a 409A valuation, because basically, if you sell stock for too little money, the IRS could come and say, oh, that was worth more. You have some tax implications. That would not be great. But if you issue options with an exercise price that is lower than the fair market value of the time of grant, that's a more serious violation, and that you can get into things like sort of backdating options or underpricing options, which in the past people have used sort of strategically in order to give themselves benefits, but they did that sort of in violation of securities and IRS regulations, and so there can actually be penalties for underpricing options. So we typically tell people to use stock. Options are really I think in the Series A, Series B stage, so you can they're easy to issue because there's no immediate tax implication. So even if the underlying stock is worth a lot of money, because you're issuing it as an option, there's no immediate tax on the recipient. So it's sort of the Series B, Series A, Series B stage. That's when you really want to be issuing options, and then as a company gets more mature, that's when you can move into RSUs and other kinds of you kind of go back to stock, but you can issue it. The way that RSUs work is basically they're restricted in such a way that, again, we're avoiding immediate tax implications to the recipient. So and I think the reason options don't work at the later stages is, if your company's already valued at $50 million, even if you go public at $100 million or $200 million, there's still an incredible amount of cost to that exercise price that you would have to pay to exercise the option. And at that point, there's also a downside, right? Your options may go underwater, right? So you may issue options based on the Series D valuation, and then do a Series E at a lower valuation. And all of a sudden, those options are underwater and they're not worth anything, and they're not incentivizing the employees, the way that they should be. So that's sort of the life cycle of it. I think what people don't think about, and one of the key, this is not the only consideration, but one of the key considerations here is all of these employee equity solutions are really geared toward, obviously issuing equity to employees in a compliant way, but B, issuing equity to employees in a way that doesn't create immediate tax obligations. You don't want to give your employees equity and then tell them that equity is not liquid, you can't exchange it for cash, but you have a big cash tax bill due to the IRS at the end of the year. So that's one of the main considerations that we're looking for when we're trying to figure out how to structure employee equity.
Wonderful. Thank you so much, Kate and Nick. We have a few questions, but we do not have much time in hand. So with that, I'd like to thank you, our mentors and guests, for joining us today. And we will be back soon with more workshops. Again, I would like to bring your attention back on the screen for our upcoming events. We host events on a weekly basis. We hope to see you again at some point of time in our virtual events. Till then, take care, stay safe. Thank you, and have a great day ahead. Thank you for your time, Kate and Nick, today.
Thanks for having us.
Thank you for having us.
Wonderful. It was our pleasure. Thank you.